Cary, thank you for joining me today. We are going to talk a little bit today more about settling an estate in Florida. Tom has talked to us some about the probate process, but we want to get more in depth outside of that process. Um, so this is really going to let executors, personal representatives, heirs know what they need to know, essentially.
Mhm.
So first, let's just paint a general picture for people. You guys have worked with a lot of personal representatives, worked on a lot of estate settlement. Give us some examples, or give me a story about one estate that was easy to settle, and then one that was difficult or took a long time or had a lot of roadblocks in the process. What was the difference between the two as well?
So probably the easiest ones are those where you have individuals that are organized. They have all of the paperwork, handy. They have a good relationship amongst all the beneficiaries. For example, one of the three children is serving as the personal representative. All three kids are very responsive. They have a good relationship. They also acknowledge the fact that yes, this is what mom and or dad wanted. And so with those individuals, you're kind of hitting your marks and keeping the progress going very smoothly. And, there is no roadblocks, there is no surprises. Because again, we have all of that detailed information up front. We have, that original will. Everybody had a copy of it. They were well informed prior to their parent passing. And again, when you've got those clients that are very responsive, that when you ask, I need X, and they jump on it the next day, that is really going to keep the probate moving forward. And again, no conflict. So that tends to make things run very smoothly. On the flip side, I'm dealing with an estate right now where we had two co personal representatives. One happens to be an attorney, and one is another child of the three children who is not very sophisticated. Not that that's necessarily a bad thing, but we have two very different personalities trying to administer the estate. And it just seems that every time we turn around, we're sending out communication, we're sending out documents to review. It's just every time and there's a delay. And there's, I think probably obviously some history that's gone on for many a years between these siblings. And I think there's a level of distrust amongst them. So it just tends to slow everything down. And also, the less sophisticated one had been living with the parent, um, had not really had things organized, was helping the parent, so to speak, but just didn't have a good grip on what existed. And so that estate has taken far in excess of what a reasonable estate should take, which the statute tells us is 1 year for a non taxable estate. And it's taken us far longer because of those roadblocks that we're hitting. We're finding assets well after, that the process was started, and almost a year into it, we've just discovered another asset. So those kinds of situations will extend that period many times unnecessarily, just because you have two co-personal representatives that just don't work well together and aren't able to move things along in an efficient manner.
Let's talk worst case scenario. There's no will. What happens? Who becomes the personal representative? And then, like, what is the first thing that happens after a personal representative is identified?
So if there is no will, then it's said that the that the decedent died intestate, right, without a will or estate plan document. And so the statute has a priority of individuals that have preference in serving as the personal representative. And so you kind of look at that, what that pecking order is. Now, if you have, let's say, three children and all of them agree, because they have kind of equal footing, right? If there is no spouse, if they all agree, yes, we want, uh, our sister Susie to serve as the personal representative, then we have everybody sign, consents to that effect and waiving their right to appointment. So as long as we have that consensus about who should serve, and then we're filing that with the court to show the court, look, everybody's in agreement. They want this particular individual to serve as the personal representative. And then the court, assuming that the individual doesn't have any felonies or anything like that, then they would be qualified and appointed to serve as the personal representative. Where you have an issue is if there is no will, so we don't know, who the decedent would want to serve, and you have disagreement amongst the same level of priority that's listed in the statute, those individuals, then you start to get into, you know, a um, a situation where you've got disputes and people objecting, and it's almost like, who's getting to the court first, and then there's, it will snowball from there if there's not a consensus, because of course those that are not in agreement will object.
My family just watched the first Knives Out movie. I don't know if you've seen that where
I haven't.
yeah, it deals with all that, and I think this next scenario is kind of painted out in that one. Let's say there is a will, but
Mhm.
you have an heir that objects. What's the next step? What happens? Is that even possible? And like, what's the worst thing that somebody could do as well?
Well, I think, the will itself is showing the decedent's intent, right? And the court is going to defer to that unless there's some reason, legitimate reason that that individual should not be appointed as a personal representative. Again, if they're a felon, a convicted felon or something, there's got to be some evidence to suggest that this person should not be put in that position. But the court takes, the decedent's intent and wishes that are spelled out in the last will and testament. They take that and show deference to that, right? They want to ensure that they are honoring what that individual chose at the time that they signed that will. So if somebody's going to object to that, they have to have a legitimate reason for objecting to that person's appointment or the legitimacy of that last will and testament. And, kind of the main um, uh, uh, main reasons that people would object to a will or have some standing to do that would be, if the will was not executed properly, right? It wasn't signed by the decedent or the testator, we call it, in the presence of two witnesses, or if there's some evidence to reflect that they were incapacitated when they signed it, or they were unduly influenced. So you can't object to the will just because you don't like what the will says. There's got to be some legitimate legal reason to do that. And again, if you're showing that, listen, this person should not be appointed as a personal representative because of these reasons, then the court will take that into consideration. But ultimately, they're going to defer to what the will says.
Now, let's talk about some problems that might come up. You talked a little bit about, you know, potentially having to sell assets and things like that. But what is your quick test for if there are costs that come up? And let's say someone has a lot more real estate than they do actually liquid cash. Um, how do you decide when to sell assets or request versus requesting contributions from the heirs or the personal representative to cover costs for the estate?
Well, for us, we're always going to ask the question to the beneficiaries, right? Because if there is a beneficiary that really wants a specific piece of property, but we don't have the cash to support it in the estate, then they might want to step up. They have the liquidity themselves to be able to maintain that so that they in turn can receive that. So, first and foremost, I think always ensure that you're communicating with the beneficiaries to say, here is the challenge, here are our options. And if there is somebody that is particularly interested, and I've had that situation where somebody's like, look, I really want to hold on to this piece of property for whatever reason. I mean, whether it's a sentimental factor, a future investment because they always bring their family to Orlando if the property's here and they always go to the different theme parks. I mean, there can be different reasons, but I think you can't, unilaterally make that decision. And I think the personal representative has an obligation to say, this is what we're facing. And we need to have consensus amongst the beneficiaries to ensure that we're giving somebody the opportunity that if they want to, have that property, they may have to contribute initially so that we can maintain those expenses during the course of the administration.